Why trust administration matters. Trusts are created to provide certainty, protection, and continuity. Yet when a trust becomes irrevocable, most often at death, and sometimes at the incapacity of one of the trustees, that certainly can quickly disappear. Administration is where even the best drafted trusts either succeed or fail. Errors at this stage expose trustees to personal liability, delay distributions, and frequently lead to litigation. These risks increase, not decrease, as estates become larger, more complex, and more geographically diverse. In this video, we'll cover the fundamentals of trust administration, explain why professional administration by a law firm matters, examine the dangers of family members serving as trustees, particularly as dementia and cognitive decline enter the picture, and compare how these issues are addressed under Texas and California law. Hi, I'm Ben Vojtik, partner at the Hartley Law Group and licensed to practice in Texas and California. In this section, we'll start with the basic building blocks of trust administration and fiduciary duty. Trust administration, Texas and California perspectives, fiduciary duties, risk, and professional oversight. Now, why this matters. Trust administration does not equal trust drafting. Trustees face personal liability. Errors compound over time. Now, what is trust administration? Trust administration begins when a trust becomes irrevocable. From that moment forward, trustees are bound by fiduciary duties imposed by statute, case law, and the trust instrument itself. Administration is not informal, optional, or flexible. Trustees must identify their authority, marshal and value assets, determine beneficiary rights, provide required notices, prudently manage investments, maintain detailed records, file tax returns, prepare accountings, and distribute assets strictly according to law and the terms of the trust. Failure at any step can result in surcharge, removal, or personal liability, regardless of whether the trustee is a family member or a professional. Next, we'll look at the fiduciary standards that govern every trustee. Core trustee duties. You need to identify trustee authority, collect and value assets, notify beneficiaries, prudently manage investments, accounts and reporting, tax compliance, and distributions. Fiduciary standard involves the duty of loyalty, duty of care, duty of impartiality, personal liability for breach. Federal law and UPC non-negotiables. Some trust administration requirements apply everywhere. At the federal level, most irrevocable trusts require a new employer identification number, or EIN, through IRS tax form SS-4. Annual fiduciary income tax reporting is completed on IRS Form 1041 with Schedule K-1s, issued to beneficiaries reporting their distributable share of income. For larger taxable estates, trustees may also be responsible for filing IRS Form 706, the United States Estate and Generation Skipping Transfer Tax Return. Overlaying these tax obligations are fiduciary principles, reflected in the Uniform Probate Code and adopted in whole or in part by many states. These principles emphasize transparency, beneficiary rights to information, enforceable remedies for breach of trust, and court oversight when necessary. Importantly, these requirements do not become simpler when trusts hold multiple types of assets or assets located in multiple states. In practice, they become more complex, time-sensitive, and more exposed to error. Next, we'll examine how these principles are implemented under Texas law. Federal requirements, EIN for irrevocable trusts, that's IRS Form SS-4, annual fiduciary income tax return, Form 1041, beneficiary income reporting, Schedule K-1, estate tax filing, where applicable, that's Form 706, Uniform Probate Code fiduciary principles, accountability and transparency, beneficiary enforcement rights, remedies for breach of trust, court intervention when required. Texas is often viewed as trustee-friendly due to its emphasis on independent administration and limited routine court involvement. However, reduced court supervision does not mean reduced fiduciary risk. Texas trustees are governed by the Texas Trust Code and the Texas Uniform Prudent Investors Act. Beneficiaries may demand a formal accounting under Texas Trust Code sections 113.151, and trustees must respond within statutory deadlines. Texas does not mandate standardized statewide trust administration forms. Instead, trustees must be prepared for formal pleadings, such as applications for accounting, applications to require bond, or applications for trustee removal when disputes arise. Regarding bonding, Texas trustees are not automatically required to post a bond unless the trust instrument requires it or a court orders it for cause. Beneficiaries may petition for bonding where there are concerns about mismanagement, conflicts of interest, or incapacity. We'll now contrast this framework with California's more structured statutory approach. Texas Trust Administration highlights. Texas Trust Code governs. Independent administration is common. Accounting upon demand. Limited routine court oversight. Texas risk areas. Failure to provide routine accountings. Improper distributions, self-dealing, inadequate documentation. California takes a more structured and statutory approach to trust administration. Trustees are subject to strict notice, disclosure, and accounting requirements under the California Probate Code. One of the most critical requirements is the notification by trustee under Probate Code section 16061.7, which must be served on beneficiaries and heirs. This notice triggers firm deadlines for objections and challenges, making accuracy and timing essential. While California does not use a single standardized accounting form, statutory context and formatting requirements are detailed and accountings are frequently scrutinized in litigation. Bonding rules differ from Texas. In California, a trustee may be required to post a bond unless the trust expressly waives it, and courts retain broad discretion to require bonding where appropriate. For professional non-relative trustees, bonding is common and often advisable, particularly in high-value or contested estates. Next, we'll explore how these rules intersect when trusts hold assets across state lines. California Trust Administration highlights. California Probate Code. Mandatory trustee notice. Detailed accounting standards. Active fiduciary litigation environment. California risk areas. Missed notice deadlines. Accounting defects. Delayed distributions. Trustee surcharge actions. Trust administration becomes materially more complex when a trust holds assets across multiple categories, such as real estate, operating businesses, and investment accounts, or across multiple state jurisdictions. Each asset category may implicate different governing laws, tax rules, valuation standards, and court oversight. Real property is generally governed by the law of its location. Operating businesses raise fiduciary and valuation issues under state-specific statutes. Beneficiary rights may vary depending on which state's law applies. In these situations, administration is no longer just about following the trust instrument. It requires coordinated compliance across jurisdictions, careful management of overlapping deadlines, and a unified fiduciary strategy. Consider a Texas-governed trust administered by a family trustee in Austin. The trust owns a rental property in Pasadena, California, and an operating business in Texas. The trustee complies with the Texas accounting requests under Texas Trust Code 113.151, but fails to timely serve California's Probate Code, section 16061.7 notification by trustee. Years later, a beneficiary challenges the administration in California, alleging tolling and surcharge. What appeared compliant in Texas becomes exposure in California. This is not misconduct, it is structural complexity. Professional administration allows these jurisdictional issues to be identified, coordinated, and managed from the outset. In the next section, we'll see how these complexities intersect with trustee capacity and dementia risk. Multi-state and multi-asset complexity. Multiple governing laws, overlapping deadlines, multiple courts with potential jurisdiction, increased fiduciary exposure. Why unified structure matters. Fragmented advice increases risk. Unified administration reduces conflict. Centralized fiduciary oversight. Consistent multi-state compliance. Many trusts name spouses, adult children, or siblings as trustees. While this often feels appropriate, family trustees face risks that increase significantly as trusts become more complex. The most underestimated risk is cognitive decline. Dementia rarely appears suddenly, it develops gradually through missed deadlines, inconsistent decisions, incomplete records, and confusion around legal obligations. In multi-state trusts, the consequences of declining capacity are magnified. Missed deadlines in one jurisdiction can compromise rights in another. Conflicting court orders may arise. Emergency court intervention becomes more expensive and disruptive. Neither Texas nor California provides automatic trustee removal based solely on cognitive decline. By the time problems are identified, significant damage may have already occurred. In our final section, we'll look at how professional law firm-led administration addresses these risks. Risks of family trustees, emotional decision-making, conflicts of interest, limited multi-state experience, personal liability exposure. Dementia and incapacity, gradual onset, no automatic removal, multi-state consequences, court involvement often required. Professional trust administration by a law firm is not about adding complexity. It is about managing it. A multi-state law firm offers institutional continuity and unified fiduciary oversight across Texas and California. Licensing in both states allows administration to proceed under a coordinated strategy rather than fragmented legal advice. Where court access in additional jurisdictions is required, pro hoc vice admission preserves continuity while respecting local procedure. Professional administrators also proactively evaluate bonding requirements, whether mandated, waived, or advisable based on the trust structure, asset profile, beneficiary dynamics, and capacity risk. The result is an administration that is transparent, defensible, and resilient over time. Why a law firm? Institutional continuity, multi-state licensing, coordinated fiduciary strategy, proactive risk management. Value for high net worth families, asset protection, reduced family conflict, predictable outcomes, long-term fiduciary stability. Trust administration is where estate planning becomes reality. Whether under Texas or California law, trustees face non-negotiable duties, real liability, and increasing scrutiny. For complex multi-asset and multi-state trusts, professional administration provides clarity, stability, and protection for trustees and beneficiaries alike. Administration matters as much as drafting. Texas and California differ, but fiduciary risk exists in both. Multi-state complexity magnifies exposure. Professional administration protects everyone. My name is Ben Vojtik. I hope this video has been helpful. For additional information, please check out our website.